My name is Damien McElrath. When I was 18 years old, a few weeks after being diagnosed with schizophrenia, I killed my adoptive mother because I believed she had been poisoning me. I was charged with malice murder, felony murder, and aggravated assault. I was found not guilty by reason of insanity on the malice murder charge and guilty but mentally ill on the other two charges.
My name is Stephen Petroni. I am the Solicitor General of the state of Georgia. Under Georgia law, a jury's verdict in a criminal case can be set aside if it is repugnant, or involving affirmative findings by the jury that are not legally and logically possible to exist simultaneously. In this case, the jury's verdicts of not guilty by reason of insanity and guilty but mentally ill are repugnant, because they rested on affirmative findings of different mental states that could not have existed at the same time in Mr. McElrath's mind. Therefore, both verdicts should be nullified, and Mr. McElrath should be retried.
But what about the double jeopardy clause of the Fifth Amendment? Because I was found not guilty of malice murder, I may not be put on trial again for the same crime, regardless of the jury's reasons for finding me not guilty.
No. Because of the repugnancy doctrine, there was no valid verdict of not guilty pursuant to Georgia law, and thus no acquittal. Since you have not been acquitted, you may be tried again for malice murder without violating the Fifth Amendment.
We'll see about that. The question we will rule on today is whether the jury's verdict that the defendant was not guilty of malice murder by reason of insanity constituted an acquittal for double jeopardy purposes, notwithstanding any inconsistency with the jury's other verdicts. And our answer is yes.
I concur.
What? How did you make that decision?
The jury's verdict of not guilty of malice murder by reason of insanity constituted an acquittal for double jeopardy purposes. An acquittal is an acquittal, regardless of any apparent inconsistencies with other verdicts that the jury may have rendered. And the idea that a verdict of acquittal cannot be reviewed, either on error or otherwise, is perhaps the most fundamental rule in the history of double jeopardy jurisprudence. The jury holds an unreviewable power to return a verdict of not guilty, even for impermissible reasons.
But the Georgia Supreme Court nullified the not guilty by reason of insanity verdict because it was repugnant to the jury's other verdicts. No verdict was issued under Georgia state law, so there was no acquittal and no Fifth Amendment concern.
The Supreme Court cannot agree. Whether an acquittal has occurred for double jeopardy purposes is a question of federal, not state, law. And under the Fifth Amendment, inconsistency in a verdict is not a sufficient reason for setting it aside.
I agree, but I would like to clarify the scope of our ruling. In some states, trial judges refuse to accept inconsistent verdicts and send the jury back to deliberate further. Our decision today should not be understood to express any view about this practice.
But in this specific case, since Mr. McElrath has already been acquitted for malice murder, he cannot be retried for that charge. The judgment of the Supreme Court of Georgia is reversed, and the case is remanded for further proceedings, not inconsistent with this opinion.
You rule, Supreme Court.
You suck, Supreme Court.